Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today I'm going to answer a listener question about changing pay on death designation sort of beneficiaries on joint bank accounts. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, so if you listen to this podcast or to my videos on the regular, you know I always invite you all to ask me questions. If you have them, someone, once again, took me up on that offer. So I'm going to read you the question, and then I'm going to give you the answer, and all the while encourage you to continue asking questions, continue liking and commenting and doing all the things that you're doing, subscribing if you can. And I want to just say thanks for trusting me with your questions and with your time. All right, so let's get into this. It's a question that actually was asked on my Instagram page at CMS Law Firm. I'm on Instagram too. It's a lot of all the same content most of the time. But if you, but I'm going to look off the screen if you are watching this on video, so I can read the question and then I will answer the question and then we'll go from there. All right. So let's see. Mason says, first, Chris, I've been listening for the past 2.5 years. The PCs are great. Thank you. Question, elderly married couple. Husband in his last 8 months of life separates his assets by making his wife a joint owner on account A and his biological daughter on account B. Stepdaughter is pay on death on the joint account with the wife. The elderly wife changes the transfer on death designation to her biological son as she knows he will take care of her. California law states any owner can do anything they want, and California law states that when the spouse dies, 100% ownership of assets in joint accounts become the surviving owner's property, and there is no way to pay out any listed pay on death beneficiary. Is it the same or similar in Washington? Question mark. Okay, so a little bit to unpack there. First of all, when we are talking about joint account holders, I've done some videos on this with regard to real estate. You can add a joint account holder on a bank account, just like you can have a joint account holder on a piece of real estate. When it comes to the bank account, the designation matters as well. It's not tenants in common or joint tenants with rights of survivorship. You can add someone on your bank account as a joint account holder, which, as this person has sort of noted, when one person dies, the other person becomes the sole account holder on that account. Okay. Before I say anything else, let me tell you, if you want to transfer your bank account to somebody when you die, I would suggest that you don't do it this way. There are problems with that. They could take the money out of the account while you're still alive, for one. If they would have some sort of debts that are collected on or some sort of garnishments or some things like that, there's a potential that creditors for the other person could attack and attach their claim to that account. So I don't recommend that often. If you want somebody to be able to use your account for you, execute a power of attorney. Okay, that will give them the ability to do that, and your assets will remain relatively safe. Okay, but you can also add somebody on your account as a signer only, which does not allow them to sort of take over the account when you die. In this case, it sounds like the dad or the husband added on wife on account A as a joint account holder and daughter on account B as a joint account holder. Assuming that husband died, which we did not hear for sure in this example, but assuming that, once the husband dies, the wife becomes the sole account holder on that account. Once that happens, she is free to change the pay on death designation to anyone that she wants, including her son. So she has the right and the ability to cut out the stepchild, which it sounds like may have happened in this hypothetical situation. I don't know if it's hypothetical or not, but the answer is yes. And then whoever that pay on death designation is, when the wife dies or when the mom dies, whoever it is, then that account is going to pay out to whoever is designated on the transfer on death designation. That's why you have to be careful if you're giving your assets to someone and they promise they're going to give them to someone else. You have to just assume that they're not going to follow that promise. Okay? They don't have to. They're under no obligation to. If you want to be assured of something like that happened, then you want to create a trust, and then you can create provisions in the trust where you carve out some assets for someone. Those assets are managed by a separate trustee and made available for that specific person. And when that specific person dies, you can dictate in the trust that whatever's left goes to the other person that you want. That's what I would have done in this situation. I would have had that bank account pour into a trust. I would have told the trustee that those funds are available for the wife for support, health, maintenance, education at her request. So she asked for them. Then the trustee would distribute those. When the wife dies, then whatever's left goes to the daughter, his biological daughter, husband's biological daughter, instead of husband's stepson, which he clearly did not want anything to go to. Okay? That's it. That's the question. That's the answer. So a lot packed into that. It's actually a really good question. So the bottom line is, know what you're doing when you do it. And the best way to know that is to talk to an attorney. All right? So that's it. As always, if you like this video, please hit the like button. If you know somebody who's here, just share it with them. If you're someplace you can subscribe and you don't want to miss these in the future, please subscribe. I'd love to have you. All right? And if you have questions related to this or anything else, probate or estate planning related, then go to cmslawfirm.com. You can set up a time to talk with us over the phone for free, cmslawfirm.com. Okay, that is it for today. As always, I am Christopher Small. I am the owner of CMS Law Firm. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.